I'll just let you know, give you an update of where we are, where we're working on several counter proposals at the same time, and I thought you know how sometimes you get hooked up on a couple little details and it takes longer than you thought it was going to, so we're kind of hashing out through those. If I'm hoping that we can have some counter proposals and maybe even some tentative agreements here by the end of the day, but if because of timelines or whatever we don't get there, what I do plan on doing is finishing those counter proposals and getting them to you emailing them to you before the next meeting, especially because we only have one meeting next week. That way we can expedite that and you have an opportunity to review it and ask the questions that you need to when we meet next.
Okay.
So that's my plan. And then I received 6 counter proposals from you.
Should be 7.
Oh, 7. Let me see.
I just sent you, the latest one I sent you was duration.
Okay.
And I'd like to give you a little bit of explanation of a couple of those proposals.
Yeah, that's really, I wanted to meet and kind of go through those counter proposals, because we started going through them and then it was taking too long. I said, let's go and walk through it with them, and then we can get questions as they go.
Why don't I just go through them chronologically, unless you have specific questions?
No, not at all, no. Let's go chronologically.
Okay, the first one is Article 4, then duration.
Okay.
Y'all had proposed until September of 2018.
Mm-hmm.
We proposed as an alternative an additional year. We're not really dead set on that. We noted that November of 2018 is going to be an election cycle for the city, and so we thought it might make sense to have the contract end in an off election year.
The elections in 2018?
Yeah, there'll be a November 2018, and let's say, for example, that September 30th comes up when we're in the middle of impasse or whatever, trying to be dealing with elections.
Okay.
So, I mean, if it doesn't matter to y'all, we don't have if we have an impasse procedure in effect, it doesn't have a lot of effect anyway, and so we're okay with 2018.
Okay.
And what I put, it looks like an evergreen clause, but it's really not. It just says that the agreement continues until you get a successor, either because we've negotiated one or we use the impasse procedure.
Right.
And that's a procedure that, can happen within a few months. Even if all the timelines are extended to their maximum, I think, within 3 or 4 months you should have a decision. So that's not any kind of indefinite period.
Okay.
It's very finite.
I see, and we're pretty close on the impasse procedure, and I think once we see it's taking form, and I think there's a few,
Yeah.
in my opinion, there's just kind of a few details we just need to iron out. So
Yeah, we're very close.
seeing as where we are on the impasse procedure, that makes sense. I understand where you're coming from.
Okay.
With regard to the extra year, of course, we have to look at budgetarily what, it's how we're going to do that. We're still talking, we're talking about wages. I think y'all proposed like a 4.5, and we proposed a 4. So there's it's pretty close in time. We'll let that part play out. But I understand that. I do appreciate the notation about election year.
Yeah.
We'll look at that.
Okay. Yeah, we feel good about either 4. Well, let me see. This is 15, so the 18 would be a 3 or 4 year. It'd be about a 3.5 or a 4.5 year agreement. We're not really wedded to one or the other.
Okay.
We didn't want to take it back to 17 because then we'd be bargaining again
Right.
in 18,
Right.
18 months.
We'll consider. I'll look
Okay.
at that extra year and see.
The next one is article, and of course we can kind of leave that question open, and if we see the whole contract taking shape, we can both decide then whether we want it to be a 4 or 5 year.
I think we could possibly table that until we finalize the impasse procedure, and the date would be in accordance to what the the wage terms and all that other stuff.
Right.
I agree with that.
Right.
I think we have addressed the key issue. I think was the evergreen clause, kind of like the open-ended kind of deal. And
that's gone.
right. And so I'm encouraged. I think we're close on that as well.
The next one's Article 6, management rights.
Okay.
And to me, it's all one cup of tea. Management rights, and then the Article 35 that we're going to talk about in a minute, the complete agreement, and the maintenance of standards. But on the actual specific language of management rights, I think we're close. I eliminated some of that verbiage of the last part of the opening paragraph because I thought it contradicted the rest of it.
Right, we talked about that earlier, and
Right.
that wasn't the intent, and I've,
Yeah.
I knew the reasoning for that.
Okay. I used your 21 items. I only eliminated one, and I'll talk about it in a minute.
Okay.
But the changes in most of the others are either because they seem duplicative to me or something like that. Like, for example, in number 4, classifications and ranks. Well, ranks and classifications are the same thing.
Right.
So I just chose classifications because that's how the Civil Service Act describes it. I changed a word here or there to make it shorter a little bit. And like number 9, it looks like I eliminated something to exercise the right of assignment. But then if you look a little bit higher up, you'll see the right of assignment preserved someplace else.
Okay.
I'm not finding it right now, but some of those that I eliminated like that is because I thought that had already been discussed in another one, and I'm trying to not be too duplicative.
Okay.
Same with going on the second page, 11, transfer assign. There's another specific provision that talks about transfers or something like that.
Okay. So, for instance, like the right of assignment, by you eliminating right of assignment, doesn't necessarily mean we don't have it. You just thought it was duplicative and
Right.
retained it in some other, in some other way.
You did a pretty good job.
Number 6, it has.
Yeah.
Oh yeah, to
Assign work.
allocate assigned work duties over time. Okay.
Yeah, so that was all I'm really doing in most of those. 13 looks like a major change, but again, you talked about, I think like one of the very first ones you talked about, the number 4, the size of the fire department termination duties number. So it's just, they're not really substantive changes.
I did have one question when I was going through these, because I've already started working on this particular one. On number 7, you changed the word manning to staffing. I just wanted to make sure, to me, staffing and manning kind of mean the same thing.
They do.
And I just wanted to know if there
Manning,
was any
it's like calling God him as opposed to her.
Right,
Some
right.
people, it's just, manning is kind of a sexist term that maybe a female firefighter wouldn't.
It's an older term that's been used
Yeah,
in collective
but
bargaining forever. So
there's no intent to change the.
And that's what I anticipated. I just wanted to make sure we're both on the same page, that it means the same thing.
Right.
Okay.
Why did I cross out item number 20 to contract or subcontract out work as allowed by law? I just think that's a little too misleading. You can't, I think the law is pretty clear that you can't, when you have a civil service fire department, you can't contract out or subcontract out the work of the firefighters, the classified firefighters. If you want to put to contract or subcontract out work that's not required to be performed by classified firefighters or something like that.
Firefighters.
Certified, yeah, I could probably go with that. I mean, it's not, but.
And you're basically talking about the Civil Service Act.
Yeah, there's just a whole slate of decisions going back to 1960, the old Wallace decision that talk about you can't really subcontract out the work of a civil service fire department.
Okay.
So, and I just think that's a little too, in that last sentence under the numbered items, I thought retained, and I didn't think it inherent added anything. Retained itself implies that it's something that you just already have. And I crossed out collective bargaining just because agreement is a defined term in the definitions. Okay.
So most of it's just because because you thought it was duplicative. 20, you just thought that it was misleading, or it just needs to be more specific.
Oh, Johnny's asking about number 5, and
Okay.
we had a discussion about this in our caucus. Excuse me, I'm sorry. It's my daughter's birthday. I didn't want to miss her call. I think we don't need to talk about that yet, because it had to do with this EMS question.
Oh, okay.
And I mean, I guess there's a question right now among the association bargaining team. Does the city have any present intent to abolish the firefighter 2 EMS position?
At this point, everything that we have, that specific question, as I understand everything that we have put on the table so far, no. I mean, if you look at our wage proposal, we keep, although number 5 is related to the civil service law and statute that gives the city the ability to establish classifications and numbers of people under those classifications, and then we have the inherent management right to just do job descriptions as necessary. That's really what that was based on.
Yeah.
And we have that ability already to do that. If we needed if we needed to reclassify the ranks, we could do that. At this point, that's not anything that as I understand it, we're intending to do. I mean, if we would have probably, and maybe it's something that we need to discuss. Maybe it's something that you know, for the operational needs of today's fire department here in Corpus Christi, maybe we do need to change the ranking system to better. You know, it's something that we can discuss.
Yeah. As I have pointed out to my team, the Civil Service Act specifically commits to the council the authority to establish classifications and the number of positions within classifications. Right. So you're right. I mean, subject to that limitation on your authority, and that's really more of how you do it rather than can you do it.
Right.
You do have that right, and obviously you know, unless there's something in the agreement that says you can't, you have the right to establish job descriptions and you know, and to come up with the work of the various classifications.
When we were looking at the, you know, and doing this proposal and dealing with these management right issues and what we retained, we weren't looking specifically at, you know, EMS or, you know, just one position or anything like that. We were actually looking at it globally. What does the city retain in the court? You know, what does the law give us? What does the law limit us? What management rights do we have, so that we know what we need to, when we bargain, what we're giving away. You know, because we have to give, you know, it's a give and take, and
sure,
we have to give away those rights through bargaining in order to deal with the working conditions, the hours, and compensation. So
yeah, and you know, I mean, if we really spent the time, and we don't need to spend the time, and went through all of this list, we would find that there are specific provisions in the contract that do limit a number of these rights. For example, you know, number 7 gives you the right to change modify or change work schedules. Well, you've already given us a proposal that says for operations firefighters, their schedule's going to start at 8 o'clock and end at 8 o'clock.
right, those are work hours, right?
Yeah.
So
you know, I mean, to some extent, there's a lot of these things that are either already limited in some way by statute or by the contract itself.
But it would be too tedious to say, you know, for Johnny, he's going to work, you know, this, and this shift every time, you know, because that's just not doable, and it doesn't work out all the time, and we have to have that ability to manage, you know, if somebody's out sick or you need a vacation, okay, you have to switch over, because then our hands are kind of tied there.
Yeah.
And for the organization or the department to be efficient in its operations, we need the ability to kind of fill in that spot. And that would be too tedious to do it for each and every one of the firefighters.
Yeah, no, I agree.
So, so that's why, you know, we know that hours of work is something that's important to y'all, and y'all need to know what is going to be expected of you in those hours, and that's why we establish it like that, especially on the shift work. You know, that's very important.
But in answer to Johnny's question, you didn't formulate item number 5 with an idea towards this is going to give us the right to abolish firefighter 2 EMS position.
No.
Well, you know, we're actually close, I think, on the wording of this. So, I mean, although there are some wording differences, substantively, I think we're close. So, just ask y'all to look at that and see if there's anything in there that still gives you a little heartburn. Let me see, I think the next one is 7. And item 7, all I did was I took out the maintenance and standards provision, because I'm going to include it in Article 35, which we'll get to in a minute.
Okay.
But other than that, and I would point out that this is one where I would think that we could, you know, with the sections 2, 3, and 4, we might be able to come to a tentative agreement on that. Oh, wait, I got the wrong one. Today, because you know, all of those are existing contract things, and at least one of them I know you've already proposed back to us.
Yeah, the written
language of written
regulations.
rules and regulations.
And that's pretty close as well. Okay.
Yeah, so, you know, 7's one that we might be able to get an agreement on today, even if you want to try and do that. The next one is Article 21, which is work schedules. What I did here was the ones that are in agreement with your last proposal, I put in green. I kind of
Okay.
followed your idea. And then I tried to indicate in the blue underlined where I differ with you
Okay.
on holdovers. I don't think you meant to do it, but you said the city's not required to provide additional compensation for holdover assignments if the firefighter is required to hold over to be on standby or dispatched to a fire to relieve another crew. Well, I mean, if you're dispatched to a fire to relieve another crew, you might be on the scene for hours and hours.
Right.
And I don't think you meant to say, well, they have to work for hours without compensation.
No, that it was meant to maintain, I believe, if I recall correctly, it was meant to maintain the status quo of what's already in the old contract.
Right,
So-
right. So I just put some language in there to kind of clarify what I think both parties intended, but just look at that.
Okay.
On the straight time compensation, I understand what you're trying to do here is to say that the pay that we provide covers straight time compensation for all your regularly scheduled hours. But once every quarter, the regularly scheduled hours do not add up to 216 in a 27-day cycle. In a Kelly Day cycle, there's only 192 hours that are actually worked. So I didn't want that to be like, well, okay, in a Kelly Day, if you make somebody work an additional 24 hours, you know, that's already been compensated.
Yeah,
by
we didn't intend to.
No, I know
take
you
Kelly
didn't,
Day,
and so I'm just,
Okay.
I'm sorry, I'm just compulsive and cautious. So that, I don't think that's a substantive change either. So
Okay.
this is another one. And then you'll see that E, you agreed to your language. And then on section 2, you know, the first area of disagreement is the captains and below. You know, what I've highlighted in yellow is our proposal. That's what's in the current contract. You've changed that to say that the fire chief can alter the schedule of firefighters and fire prevention at any time. You've taken out the 50% or less.
Oh.
I'm not aware of any problems that are currently exist, and so we're asking you to consider just maintaining the status quo. The language that I have there that's highlighted is in accordance with the existing contract. So A and C, as you can see, are in green, and we're in agreement. Your city proposal didn't say anything about that special holiday provision.
Okay.
And that just really maintains the status quo. Firefighters who work a 410 are given, 7 10-hour holidays.
Oh, okay.
Okay, so that's just to maintain the status quo with regards to that. Similarly with callbacks, my proposal, y'all didn't respond to that part of the proposal.
Oh, okay.
But I don't think it's controversial. This is actually working very smoothly. In fact, I think the chief will confirm this, that the parties presently are meeting and have just finished, I think, negotiating a new callback procedure that's going to replace the existing 101.09. And so, it's one of those, it's not broke, so let's not fix it. So I just left it in the contract. What we do is we get this new procedure, put it in place, and that's the procedure we use for this contract. We can always change it by mutual agreement, and I think the parties have just shown they're more than willing to do that when the need arises. So this is another one where I think if you look at it, we might be able to TA today or quickly anyway.
Okay. Yeah, on the On those sections, under section 2, such as 2B and 2D, I'll have to visit with the chiefs and just to make sure I understand the operational aspect of this and make sure
Okay.
that this, the status quo is, there aren't any issues with the status quo. I don't
Okay.
recall there being any issues, so I just need to double check on that.
Okay, that's fine, and I've tried to kind of indicate where they are in the current contract. It doesn't look like I put something in the captains and below, but you can find it in the work week article,
Okay.
whatever that article is. It's on page 7 of the contract.
Oh, you did note it,
I noted it.
at the end of the paragraphs. You put page
I
7.
I did, oh, yeah, I did on some of them, didn't I?
Yeah,
Okay.
I saw it and I didn't know what that was. I was about to ask you what that is. Okay.
Yeah, the page 7 refers to page 7 of your latest proposal. Okay.
Oh, okay.
The
But it's also on
contract, it
page-
just happens to be on page
Page-
7 of the contract as well, but those page
That's a good
7s were
sign.
just,
It's a good sign.
yeah, yeah, very good. Okay, if nothing more about that,
Okay.
we move on to 25. This is, again, I think we're very close here. The first change that I've made to your last proposal, and our proposals sometimes differ a little in style, and sometimes they use your style and sometimes they keep mine. But I'm really looking for substantive differences.
And just a little note on that, I'm trying to, now as we keep going through these counter proposals, I'm trying to merge those two styles so that they
Yeah.
will end up with just
There's
one.
There's
so.
one we'll get to in a minute where you did a better job than I did, so I just adopted yours.
Okay.
And I don't often say people do better than me on anything, so, the first change is there, page 1, section 1C. We incorporated your change. I added a sentence.
You're talking about 2C.
Appeals from disciplinary action?
Yeah,
Doesn't have a
2C.
one.
2C.
Okay.
Y'all wanted,
2C.
our original proposal had been the vacancies not created until the appeals run their course, which is kind of the status quo, but y'all wanted to make it happen immediately. We're fine with that. But under the Civil Service Act, if you do it immediately and, then the firefighter's appeal is successful, when that firefighter comes back, it creates a stair-step bumping down.
Right.
And people get put on reinstatement lists. And so rather than do that, we put in a sentence there that I think equates with what y'all's intent is, which is that you would create an additional position to put that person back into. I want to point out, because I think this is important, that wouldn't have to be permanent. You could temporarily create a position.
Right.
Council could adopt an ordinance adding a position for the person and then having that same ordinance say, when that position ends, or the next person that resigns will immediately
Right.
go back down, so.
And we did have some conversations on that amongst our team, and that was the intent that we talked about, ways to address that, because our intent was not to ever go down that road where we promote people, which creates a chain of promotions, and then that comes back and then we have to do a chain of demotions. We don't even want to go down that road. What we were thinking about was, if there's a vacancy, put a body in there, and that way we have as fast as we can fill it, we fill it, and then if that person comes back, if we somehow create a provisional position that we could, if we could make it permanent, great. If we can't, then, because it's all subject to city council approval and budgetary restrictions and all that stuff, that we would leave it open until that, that person leaves or person retires, et cetera, and we would put a caveat somewhere in there if that was the case.
And you may want to put language in the contract about that, because, under the Civil Service Act, there's some kind of crazy rules. NIBOR decision out of Fort Worth comes to mind, and you can get a real nightmare where you don't promote and do it right. I had a case in San Antonio where we ended up with 106 retroactive promotions.
Oh,
So,
yeah, we want to avoid that.
want that.
We wanted everybody to benefit from it. We didn't want to create any kind of traps for anybody.
Yeah, no, and that's why I'm.
So if you have any ideas or suggestions on how to get there, we'll work on it more, but I think the important part is that you understand our intent, and then we can figure out wording that will get us there and protect both sides, because
Yeah.
we don't want there to be any demotions, we don't want any, any of that
Yeah.
retroactivity.
You don't want any
And I see-
unintended consequences in either direction.
Absolutely.
Yeah, and yeah, I think we're in agreement there. So
So-
we're not, I think we're both on the same page there. Look at the language and see if
Okay.
that gets you where you want to be or you want to add something.
The other issue I wanted to address here, and maybe, when I'm looking at this and you look at the Civil Service Act, once a vacant, and this is not addressed here, so I'm just, we're bound by what the Civil Service Act requires us to do. When that vacancy comes up, we have a certain time period that we have to fill that vacancy
Right.
with. And
60 or 90 days,
Right.
depending on whether or not it listens.
And the intention was, okay, if, we thought it was okay and it was doable to do whatever the Civil Service Act requires us to do with regard to that timetable. If there's any issues on your end about that, in lengthening it, let us know. But I think, as far as I can tell, and I'll confirm with the management and everybody I need to, that, we're willing to maintain that timeline under the Civil Service Act. That's why we didn't put anything on there.
Yeah.
That's why we titled it a vacancy and not an opening, because vacancy triggers that.
Right, okay.
Okay?
Looking down at section 3, and I'm looking at the bottom of page 1, the top of page 2. This is one area of remaining difference. We put this, I do think that it is in the first sentence of section 3B is in the current contract. The second sentence is new. Obviously, we're in subsection A at the bottom of page 1, we're giving up all of those chapter 614, subchapter B protections. And so this is sort of an alternative to that. And we would ask you to take consideration of that. I don't think it's much different than what you're doing now. If you do have a policy for investigations in effect, and it seems to be working for you, and you do allow firefighters union representation when they're being subjected to an investigatory interview. So.
I do have a question on that. Like, for instance, if something in the policy had to be changed, would we have to negotiate that, since it says practices currently in effect, and I would assume at the time that this contract is signed?
I think that's, yes, I think,
Okay.
I think you would need to at least come and notify us, and we would need to have a discussion. But just like the callback procedure, I mean, it's not an area where there's been a lack of cooperation between the parties. I mean, there are some cities where there's a lot of discord about the way investigations are conducted. I haven't heard that that's the case here.
Okay.
So, if I mean,
The
I would ask you to
difference-
talk to the chief
Yeah,
and see if
absolutely.
he likes the disciplinary procedures.
So the one thing that's different with this investigation techniques is the addition of the firefighter being able to review the investigatory file beforehand. Is that right? Because that's not part of what we do
Oh, I'm
now.
sorry. That is a part of yeah.
That's new.
It's I've tried it in other places where I've negotiated, and it seems to have a kind of a salutary effect. I mean, the problem with employees, they get called in, they feel like their job is on the line, they're nervous, they don't know sometimes where the investigator is headed. Investigators sometimes feel, well, that gives me a better chance to get at the truth of the matter. But in fact, a lot of times information is left out just because the firefighter, in this case the firefighter, doesn't know how to respond, and they're nervous and they don't hear the question right. So both having reviewed the file and kind of knowing where it's headed, and having an association rep whose job is not on the line and can be a calming influence.
I don't think that at this point, we don't not allow an association representative at the investigation.
No.
Okay,
No,
so
you
the
do.
association representative can be there even right now.
Right. Your only question is reviewing the investigatory file in
Right.
advance.
I have a couple of concerns with that. You and I are both lawyers and deal with litigation and things like that. A lot of the times when doing an investigation, whether it's an HR investigation or, a disciplinary investigation or any kind of investigation, if employees know that the person subject to the investigation is going to be able to see any statements or anything that's been taken before they get to respond, I think that's going to put a limit, some sort of limitation or
It's going to make them a little
upon the
bit
witness.
afraid to come
Right.
forward.
They're
Well,
gonna come forward and they're not gonna be as forthcoming as they would if they had a protection, knowing, and not so much my, but hey, this is what happened, this is my, this is the truth, and knowing that they're not gonna suffer some sort of consequence, and not job related, but some sort of other consequence, whether it be, a social kind of deal, or,
Well,
that's one of the, that's a big concern that I have.
It's always a concern, I mean, sexual harassment complaints, as an example, I mean, a woman possibly won't come forward if she knows that whatever that even the fact that she is complaining is going to be shared with the alleged perpetrator. And so you have that clash with the due process rights of a person who needs to know what are the allegations against them with enough specificity to be able to reasonably respond. And I would say that in this case, you could offer some language, to say that they'll get the investigatory file with the exception of any statements taken under a pledge of confidentiality or something like that, so that if you have, somebody like that who's afraid to come forward, that you can protect the person in that regard. I mean, there has to be some level of trust. We have to trust that you're not using that as a loophole to drive a Mack truck through. You have to trust that we're really trying, not just to, I want to see everything that got on me so that I can, engage in avoidance. At the end of the day, with regards to disciplinary investigations as opposed to criminal, you don't have to talk to the person at all.
Yeah.
So.
Well, you mentioned the one thing that is the key component to something such as this, this is what disciplinary appeals, and with regard to investigation, due process.
Yeah.
And that's what we want to, our goal in that is due process. We don't ever want to take that away. We don't want to limit it. And there is due process because in this case, even though we have the investigation before before the chief says, yes, I did find, they could say, okay, the investigation found nothing, it ends there. But once they say, yes, there's a problem here, you have the ability to have a rebuttal. You can, you get a contemplated letter that states all the facts and all the allegations. You have the ability to submit a written response and have a meeting with the fire chief or his designee to explain your position and explain, like, if for instance you didn't understand a question, well, this isn't what I meant. I didn't understand your question correctly. If this is what you're asking me, and they have that opportunity, and it works really well.
It does and it doesn't. I mean, I think social scientists will back me up on this. A lot of times when you get to that, so-called Loudermill hearing, the die is cast, the chief has pretty much decided what he or she is going to do, and your ability to affect the decision at that point is limited. Whereas if, because the chief has already reviewed the entire file, including any misstatement you may have made because you didn't understand what was being asked, etc. And I found that if you're going to turn around that disciplinary train, your best chance to do it is during the investigation before positions have kind of hardened. Once you get to the, I don't know exactly how the chief does it here, but a lot of chiefs will hold a conference of their high-level staff and get feedback from them and then make a preliminary decision and then present it to the firefighter or the police officer and say, now what do you have to say that might affect my decision? By that time, they're pretty far down the road and it's pretty hard to change hearts and minds. The best time to do it is during the investigation when you can really make sure that all the salient facts are there and available. And I'm just suggesting that there's a happy medium here. I totally get what you're saying about you don't want people to be afraid to come forward because they know what they say is going to be revealed. There should be a way to protect that while at the same time giving the firefighter the information they need to really, because I've had you know, you get a firefighter in there and he's got 3 high-level, you know, fire chiefs beaming down at him from 3 different sides, you know, and they're just like, they're nervous, they don't.
Yeah.
So, anyway, just
Okay.
think about it.
We'll think about, I understand what, there, you know,
Yeah.
we'll consider it and see if there's anything that we can figure out on that, you know. that issue.
In C, I think, and I'm looking at the top of page 2, I think that the city I removed was removed because y'all had removed it. Okay? I think there's a provision a little bit later on that talks about this, but anyway, you know, it's the notice of contemplated action by the chief, and y'all struck it, so I struck it. But
Okay.
I don't have
I'll
any
look
better.
at that, I don't, yeah.
I don't have any better reason for it than that.
And I need to make sure if that's, if we meant to strike it, and if it's something, you know, if a copy needs to go to the human resource director, that may be, I need to look at that.
I don't
again.
know why, you know, maybe you're just trying to make sure that your human resources director has a complete file or something.
Okay.
You know, it is just a notice of.
Okay, that's just the contemplated.
In D, I changed what I'd call the notice of disciplinary action to the written statement of charges, and I used the phraseology you had suggested after the opportunity for rebuttal is passed, less wordy than mine. And I changed the, I moved where the proof of such service sufficient to support disciplinary action, and I'll explain that in a minute because it comes up again a little bit later. But down at the bottom of page 2, section 4B, in initiating the appeal, this is where it comes up. You know,
Okay.
what y'all have is, okay, if the firefighter, we can't get personal service on him or her, we serve them by certified mail and we give a copy to the union, and the 10 days starts running from when the union gets a copy. Well, that puts us in the middle of something. If you can't serve the person personally, it may be that they're ducking you, and as silly as it sounds, I've known of cases where, you know, officers try to duck service of disciplinary charges, and I say, man up, officer. You know, if they're ducking you, they're probably going to duck us too, and we don't want to be on the hook for their
Right.
time limits. You can't get in touch with them, I can't get in touch with them because they're off in Antarctica somewhere.
I think we've had this conversation before with regard to like payment of costs and so forth. As I understand it, the firefighter individually owns their appeal for disciplinary.
Exactly.
So that's where that comes up.
Yeah,
Okay.
so
It's not it's not like grievances where the association back, you know, kind of takes ownership of that and says, hey, it's passed through the committee that we were talking to, it passes through there and we're supporting this, so, okay.
Right, and we accept and applaud your idea of giving us a copy. I mean, if the firefighter is ducking service, and so you send it out by certified mail and you give us a copy, we're like, oh, come on,
Yeah.
John Doe, grow up,
Right.
answer their calls, you know.
Right, and the intent was not.
It gives us a chance to help them, but it doesn't
Right.
put us on the hook.
The intent wasn't to put you on the hook, because we understand that the firefighter, it's their own individual appeal if they want to go forward with that.
Right.
It was just to make sure we communicate with the union and make sure they know what's going on, so.
And
okay.
then you can see selection of the arbitrator and hearing date. We're in accord on that. I think I kept largely my language, but I really tried to be careful to read them to
Okay.
make sure they did the same thing. Hearing transcript, all that blue there is your language. I substituted it for ours. Pre-hearing, I went to your 2 weeks from my 1 week on about exchanging witnesses. I think you're going to find that on the procedures that I pretty much went with you. 2 weeks to do, you know, exchange witness and exhibit lists, and to subpoena witnesses 2 weeks before the hearing, and
It's
all
supposed
that.
to mirror the other procedures, like in the grievance procedure.
And I was cognizant of that
Okay.
this time, and so and on both, the one I gave you yesterday on grievance and this one, I went with your time frames, so they should line up now. But everything else is, I don't see any other. If you look at item 6 on page 4, that line that's crossed out had been in my last proposal, and you crossed it out, so I crossed it out.
Okay.
Okay, so that when you see red, it's not necessarily I'm crossing out your language. A lot of times I'm crossing out my language in favor of your language. So but I wanted you to see where I was coming from. So I think we're very close here on this. There's, there are some remaining issues maybe on the investigation, but I think with that exception, we're there.
I think the investigation is really the only big issue for me.
Yeah, and I, I mean, let's work with that item C. I can come up with language myself that I think would, but it's your turn. Okay, that was 25. Any other questions about that?
No, and I did just want to mention, I saw that you accepted on the arbitration expenses. I added except in regards to the expenses of subpoenas, or except as regards to the expenses of subpoenas.
As I understand it, we just both create our own subpoenas, give them to the arbitrator signs. Other side, we serve a copy on the other side. Our arbitrator can quash pursuant to request by the other side, and would have to make that decision. But once we get the signed subpoenas, we're responsible for getting them served.
Right. Well, and this actually encompasses a little bit more than that, because there may be, especially when we share equally in the expenses of the arbitration, there may be an instance where the union doesn't want to do any subpoenas, but I need to do like 20 of them. And I have, in order to get this, and I have, I don't have to, the only reason I would pursue a subpoena is if it was absolutely necessary, if I had to get that person, a witness there, and I needed them to have, I needed to have an order, so to say, to get them there. There's an arbitration expense associated when you request the subpoena from the arbitrator. And it depends on each arbitrator whether they,
they charge you a fee?
I've seen it. So I've had some arbitrators on an invoice charge a fee for reviewing subpoenas and saying yes. And, depending on the arbitrator, it could be, they could have one charge for the 20 I submit all at one time, or they could possibly charge for each and every one of them. And that's what that's just what I'm concerned about. If,
okay.
So,
So you're making sure that we understand that that's the expense that
right.
What I was worried about was a situation where I get the arbitrator to issue 10 subpoenas, and then you move to quash, and then the arbitrator spends a half a day studying your motion to quash, ultimately denies it. I wouldn't want to be on the hook for that arbitration expense. I think that should be borne equally.
Yeah, because we quashed it, because there was an issue. But,
yeah, but I haven't had, I'm sure you're right, I haven't had an arbitrator charge me for just signing a subpoena that I prepared, but I was thinking more in terms of the actual cost of getting a server if you have to.
Right.
In Texas, of course, anybody over 18 can serve a subpoena, so.
Yeah, anyone who's not affiliated with the
case.
The issue, the case, the lawsuit, whatever. So
I have my
we
son
need to
issue,
look
but
at
then I
that.
bill it back to you. Is this a great country or what?
Yeah.
God, I love this country.
Yeah, okay, sorry.
So I'll look at that, and
Okay.
sometimes.
Yeah, we may want to clarify exactly
I
what
may
we
clarify.
mean by
I
that.
may go look at the invoices, because I can't recall if it was a significant expense, but it possibly could
If
be.
it is, we
because-
want to rethink using that arbitrator again.
I know,
geez.
sometimes we don't have much of a choice, but
Yeah.
as you know, but we really don't have a lot of control over what they charge, once we kind of go through the selection process. So, and in this particular case on disciplinary appeals, we're using the AAA and we use one arbitrator, so. Okay, so we'll look at that.
So we're close. See, we're close
Okay,
on this.
okay.
Promotional bypass is Article 34. I almost agreed with this is the one where I went with you almost totally.
Okay, wait, I don't think that's the one, I think that's the one I'm missing. Cause I've got Article 4, Article 25, and then I have 6, 7, 21, 35, and 25. So I didn't get the promotional bypass.
Okay.
So
Well, I don't know what happened there, but let me send it to you right now.
it was, my email was acting funny earlier. It didn't receive anything, and then I received everything at once. So that may be the issue.
Probably just it's so funny, I was at the hotel last night and my internet was working fine, and then 8,000 high school students descended on the hotel. All immediately got on the internet, it became incredibly slow.
You gotta check their Facebook.
What are you gonna do? Okay, it's coming to you now.
Okay, it says it went through. I'll see how long it takes you to get it.
There it is. Okay, all right, I have it open.
Okay, on section 1A, I think this is the only substantive change that I've made. You had put that bypass by the fire chief at the chief's discretion, but then you later provide for an appeal. Well, see, I don't know what would be the appeal standard that an arbitrator would use. So I substituted at the chief's discretion for a valid reason. That is the one that's in the civil service statute. So, and there's case law, you know, that interprets that. And so I thought that made sense. I capitalized firefighter throughout because that's a term that's defined in the definition section.
Okay, yeah, I was gonna ask you about that because on some of them it wasn't, I guess one of the first ones we TA'd or were working on, it wasn't, so then I kind of started using the lowercase to try and make it consistent, and I saw you do, so I just need to reverse it, I guess.
Okay, yeah, well, you know, and we'll do that kind of cleanup.
Okay.
But the only other substantive change, I guess, is in section 1D, other than judicial appeals, that ought to be E, because I got 2 Ds there.
Oh.
I just corrected that on mine, why don't you
Correct.
on yours? The only other substantive change is on that 1D. You said when the associate represents, it shall share equally. This is kind of in the same category as disciplinary actions. The firefighter, him or herself, exercises the right to appeal. And so whether and in what circumstance we pay for the firefighter's appeal, whether we represent them is a different decision from whether or not we want to pay half the cost. I mean, it could be a situation where we think that a firefighter, that there actually was a valid reason the firefighter should not appeal, but we're willing to represent them, to lend them our expertise, and to make sure that the process is observed, but don't want to be on the hook for paying for it. So we eliminated that. The change to the voluntary promotional bypass, we just asked that the chief, if he refuses to let somebody voluntarily, that he reasonably exercise his discretion in that regard. We don't want it to be, I had an argument with my spouse today, and so request denied, or something like that. But other than that, I mean, this is another one where we could TA today if you wanted to try. And that takes us to Article 35, which is the new one. This is new, but it's not. It is a response to your zipper clause thing. And the language of both sections of this comes from the current police contract. This is the zipper clause that you have in your current police contract. This is the maintenance and standards provision that you have in your police contract. The thing that I would point out about this is that, we have never, we've had contracts between the parties since the 1970s. We've never had a complete agreement clause to my knowledge. And so, just as you were talking about the impasse procedure yesterday, this is a major change in the nature of the contract, and it's one that I have a feeling y'all want pretty badly. But I see these things as bookends. At the same time that we're relieving you totally of your obligation to negotiate during the term of the agreement, we're also asking to protect certain things. And I say that
And I talk about the trust issues that are between, that exist between the parties. I mean, it's the elephant in the room. Do we trust each other enough to do these things? I've heard a lot of concerns from your side about we're using, the current maintenance and standards provision willy-nilly and in ways we shouldn't. And I'm not, that's not falling on deaf ears. We're looking at that. We have been doing research ourselves on how and when we've used maintenance and standards. But I don't think the solution is to throw out the baby with the bathwater. You've asked for a really revamped management rights clause. You've asked for an entirely new complete agreement clause. We have really moved to meet you on both issues. But I don't think we can do that without protecting this maintenance and standards provision. So I'm asking you to consider that. We can talk a lot and get some good bargaining history about how it should be used, etc. The same as we have about management rights. And but I hope that you won't just reject that willy-nilly. As I said, it is in your current police contract, which I understand you're going to start negotiating when you finish this one. So.
Okay. Yeah, and one of the things I'd like to point out about your Article 35, which has the maintenance and standards, and we've talked about that, which was titled Prevailing Rights in the old contract. I told you I would get you some information on that, and I'm still working on it. I think I'm almost there in getting the full, complete information, so I do want to be able to provide that to you. That way when we do discuss it, we both have what we need, and you can see it with your own eyes.
Yeah. Okay. And I'm trying to gather some information from our side,
okay.
And so maybe we can have an info exchange.
Absolutely.
Speaking of information, you remember that, I'm not forgetting the economic items. We're just focused on some of this other stuff
sure.
first.
Sure.
I had asked, your overtime proposal is a pretty draconian change from the current structure, and I had asked you to get me whatever your estimate is on how much money it would save the city in overtime costs.
I need to follow up on that.
Yeah. Because that's an important consideration from our point of view. I did want to point out that there's some other items that we've got proposals to y'all currently that I don't think are too controversial. The drug and alcohol testing,
Okay.
the deputy chief and assistant chiefs. I think those articles largely maintain the status quo, and your drug and alcohol testing program and the provisions for deputy and assistants seem to be working. You may have given me something for the deputy chief and assistant.
I don't think I think that's one of the ones that we're working. I did have I did have a question on it actually. Now that you bring it up, what was the number?
32.
32.
Let me get it
pull
open.
it up real quick. And that's dated 2/5/15.
It's dated 2/5/15.
9 a.m.
Mhm.
Okay. And we were looking at the same one. There is something new on this, on your proposal with regard to the appointment of deputy chief and assistant chiefs, and that's section 1. It specifically states in the second sentence, there shall be one deputy chief who shall be appointed by the fire chief. And I don't have, let's see, I have it here.
It's Article 9,
Article
Section
9.
4, page 25.
I think it's section 4A.
Yep.
Talks about the deputy chief, and I'll read what's in the old contract. Promotion.
Oh, I've got it here.
Oh, okay.
I just finished reading it.
It just talks about promotion to the classification of deputy chief.
Yeah, there always ever has been only one, and there's always been two.
Yeah,
I mean, there's only been one appointed deputy chief position.
Right.
I mean, you can do 50 deputies if you want, but only one would be appointed. It's the same with the assistant chief rank. You know, you currently have under the contract the authority to appoint 2, and
that's assistant chiefs.
yeah, assistant
Yeah,
chiefs.
well, I'm talking about deputy chiefs, because the way the old contract is written, it says promotion to the classification of deputy chief shall be exempt from competitive examination, so instead shall be made by appointment by the chief at the chief's discretion.
Mhm.
And promotion to the classification of deputy chief, et cetera, and it's basically just talking about promotion to that certain classification. It doesn't talk anywhere about the limit or the number of deputy chief positions.
Well, do y'all have any desire to appoint more than one deputy? That's
I-
the rank immediately below the chief, right?
Right, it is. I have to answer that question, but I would assume that, the chief may, if the department gets bigger or the department has a need, you know, the chief will want the flexibility, that he currently has in order to do another deputy chief.
Well, you know, I would say make a proposal to us that reflects that and let me talk about it with my team. I don't have any real feedback
That
for
was,
you.
I just wanted to point out that was that there is a change there.
You know, Johnny's just pointed out to me that the title of the section is appointment of the deputy chief and assistant fire chiefs.
Right.
And I think what he's telling me is there probably is some bargaining history that indicates that the parties contemplated 1 and 2.
Okay. If y'all have something on that, I'd like to see it.
Well, the
And
clearest.
I'll try and look.
Yeah, well, it doesn't matter. I mean, you know, appointment of the deputy chief indicates 1, but
Right, but
that doesn't mean you can't propose to change it.
Right, okay.
So, I mean, if you think you might want the ability to appoint unlimited numbers, I mean, that's always a concern, because if you have a whole bunch of appointed deputy chiefs,
Well,
and you use that
right, we don't
to
want to have
abolish.
50. Yeah.
Well-
And we don't want to, we don't want to.
And yet, you know, I've seen departments where they appoint several deputy chiefs. I can't say, no, I'm saying that wrong. I can envision a situation in which you appoint a number of deputy chiefs and give them jobs that currently are battalion chief and lower things, and then you decrease the number of competitive promotional positions, and thereby, you know, so unlimited numbers of deputy chiefs is not something at first blush that's appealing to me.
Right, and I don't think
Because it
that's
really
the
should be a
intent.
pyramid and not
Right.
a.
And that's not the intent. I mean, if you think about it, the creation, the appointment of another deputy chief sends another, stepping ladder of promotions in place.
Unless
as-
you abolish
as
the
well.
lower position in favor of the higher. I mean,
I-
I've seen that, happen where you create an additional captain and abolish a lieutenant position. I mean, in fact, there's a
don't have that.
litigated court case in Fort Worth where that's exactly what happened.
Yeah, well, as you know, that's set by the ordinance. I don't think that's the intention. I think it's just the ability to manage the department.
Yeah,
So-
and I hear you, and if you want to make a proposal that increases the number of deputy chiefs that can be appointed, we'd be happy to consider that. I think we'd be more favorably inclined to look at a specific number than an unlimited.
I see.
Because
I
we don't
understand.
have a big department here. I mean, vis-a-vis some of the bigger cities. What do you got, about 300? 350? Yeah. Okay. So, okay, but yeah, I mean, with the possible exception of that, this seems pretty non-controversial,
Okay.
because we're just really, I mean, as you can see with the assistant chief appointments, we actually tried to incorporate something from an earlier city proposal.
Okay. So, and these were the ones that you're identifying for us to look at for possible TAs. Was the earliest we were looking at these new counter proposals, UA 7, UA 21, and then.
I think actually Article 29
uh-huh.
should be relatively non-controversial. I think I added a no furlough provision in there. But Article
Okay.
29, Article 31, 32, they seem to me to be relatively non-controversial. I still think recognition is non-controversial, which is Article 3, but I know you were looking at it towards, could we negotiate some positions out of the bargain? I told you, my thinking is we can't do that because the bargaining unit is statutorily defined, but you certainly can negotiate a different level of, you know, I've got contracts with several cities right now where they, you know, kind of exempt them out of the pay provisions. And just like you've done here with your assistant and deputies, you say, well, they're not in the pay plan, city sets their salary, you know, that sort of thing.
Okay.
But then again, you know, we've got to be real careful about losing even appointed people their rights to appeal discipline and that sort of thing.
Oh. That one was 32, Article 32, that's one of the cheapest. Okay.
All right, I think we've gone through all the ones.
We're still going through ours, so I'm gonna go and try and, see if there's anything we can work on to try and finalize today.
Okay. One other thing I'd look at is maybe article, and you know, I mean, you can only do what you can do in what remains of the day. But I'm looking to see if Article 27, which talks about the negotiated successor agreement, I've crossed some language out of the section 1 there, but that language has been reincorporated into the impasse article, so I don't think that's a big deal. But I mean, that one may be too much on your plate, but
Well, no, even if, I'm glad that we're pointing this out because next week we only have, as I said, we only have one. We had to, but we canceled it because of
Right.
a bunch of conflicts. So we have one session next week. We'll make up the other one at a later date, but in
by the
an
way, we
effort-
tentatively reserved April 20th,
Yes.
which is a Monday. If you let me know when you can confirm that my votes are available that day.
Okay.
Yeah.
It's a Monday.
Huh? I think we're, anything we can. Let's tentatively reserve it right now. If we get back and someone says, oh, I've got a big, you know, director's meeting or something, we'll figure it out. We checked with Del Mar and they're available on those 3 days of that last week, 15, 16, 17th. So we'll reserve those and then we'll do 20th.
Okay.
But what I do, I'm glad you're pointing these out because I'm trying to go through and see what we're really close on, and I do intend to be sending these to you before, so that you have them well before the next session, so that you can
Yeah.
review them as well, and that way we can kind of use it as a, you know, as a caucus time and working time. So
Okay.
I'm hoping to get all that done before we're back. That way, when we sit down, we can start talking about them. Start doing some counter proposals.
Okay, well, I think, even though we didn't spend much time together today, progress was made. So.
Yeah, I know we're making a lot of progress on our end.
Yeah, anything you can send me before the next bargaining session, I can share with the team.
Absolutely.
Start vetting counter proposals, and then you can officially give it to me at the start of the next session.
Right. For open meetings purposes, we're just giving them to you for informational, and then we present them and talk about them, because there's no action on them until we actually talk about them on the at the
Exactly.
table. So,
Exactly.
okay.
So,
Very good.
very good. Thank you
Okay.
all. Have a good weekend.
Thank you. We're gonna go back and work the